Well, good morning, everybody. Welcome back to this conference on Cuban slavery in the Atlantic world, sponsored by the Gilder Lehrman Center here at Yale. For those of you who were not with us yesterday, you missed a feast of knowledge and conversation and stimulation. And today we can promise more. We will have 3 sessions today, 2 before lunch, and then a final roundtable after lunch. We're allowing a somewhat longer lunch break today. Yesterday was a rapid sandwich. There is a near hurricane apparently hitting Cuba, Storm Eta as it's called, but it's apparently not going to be as horrible as some expected. A lot of rain, but if there's any news on that, I'm sure all of you are following it. Anyway, I'm David Blight. I direct the Gilder Lehrman Center here at Yale, and I want to very quickly thank my staff again of Michelle Zaks, Melissa McGrath, Tom Thurston, and Daniel Vera in particular, who is running all of this technology and coordinating all of us on this system. We have people from as far west as, at least west of New Haven, as California, as we will see in a moment with Ariela Gross. And then we have people from Europe and various time zones. And thank you all again for joining us. But I'm going to turn this over now to our co-conspirator here in planning this entire conference, Manuel Barcia, who will moderate our first panel today on slavery, freedom, and the law with an extraordinary and distinguished panel. Manuel, over to you.
Okay, thank you very much, David. Thank you very much to everybody who has logged in, and especially to the panelists. For this first panel of day 2 of the conference on slavery, freedom, and the law. We, as David said, we have a panel with distinguished speakers, and I'm going to introduce them all at the very beginning, if you don't mind, if you bear with me. So the first paper is co-authored by Ariela Gross and Alejandro de la Fuente. Ariela Gross is the John B. and Alice R. Sharp Professor of Law and History at the University of Southern California, co-director of the USC Center for Law, History, and Culture, and author of Becoming Free, Becoming Black, Race, Freedom, and Law in Cuba, Virginia, and Louisiana, together with Alejandro de la Fuente. Her book, What Blood Won't Tell, A History of Race and Trial in America, Harvard University Press 2008, was a co-winner of the James Wheeler Horse Prize from the Law and Society Association, winner of the Lillian Smith Award for the best book on U.S. South and the struggle for racial justice, the American Political Science Association best book on race, ethnicity, and politics, and a Choice Outstanding Academic Title. Gross is also the author of Double Character, Slavery and Mastery in the Antebellum Southern Courtroom, Princeton University Press 2000. She has published articles on the law and politics of race and the memory of slavery in the United States and France, and on the grassroots history of colorblind conservatism. She has been a visiting professor at Stanford Law School, Tel Aviv University, the École d'Haute and Sciences Sociales, and the University of Paris. Her research has been supported by the J. Simon Guggenheim Memorial Foundation, the Center for Advanced Study in the Behavioral Sciences at Stanford, the American Council of Learned Societies, the National Endowment for the Humanities, and the Huntington Library. Her co-author in this paper, who is also going to be presenting the paper, is Professor Alejandro de la Fuente, who is a historian of Latin America and the Caribbean, who specializes in the study of comparative slavery and race relations. He is the Robert Woods Bliss Professor of Latin American History and Economics and Professor of African and African American Studies at Harvard University. He is the director of the Afro-Latin American Research Institute at the Hutchins Centers for African and African American Research. His more recent books are Becoming Free, Becoming Black, Race, Freedom, and Law in Cuba, Virginia, and Louisiana, co-authored with Professor Gross, and Afro-Latin American Studies and Introduction, Cambridge University Press 2018, co-edited with George Reed Andrews. He's also the curator of several art exhibits dealing with racism in Cuba, including Diago, The Past of of this Afro-Cuban present, which was at the Lau Art Museum in Miami in early 2020. He's the editor of the Journal of Cuban Studies, the Journal of Cuban Studies, sorry. I should probably add here that he's been also sort of a mentor for me for decades now. So I know I've said thank you before, but here you again. Gracias. Then we have Professor Rebecca Scott, who is the Charles Gibson Distinguished University Professor of History and Professor of Law at the law school. She teaches a course on civil rights and the boundaries of citizenship in historical perspective, as well as a seminar on the law in slavery and freedom. Her most recent book, co-author with Jean Evra, is Freedom Papers, an Atlantic Odyssey in the Age of Emancipation by Harvard University Press in 2012, which traces one's family's interaction with law and official documents across 5 generations, from West Africa to the Americas and to Europe. Freedom Papers was awarded the 2012 Albert Beveridge Book Award in American History and the James Rowley Book Prize in Atlantic History, both from the American Historical Association. Among Professor Scott's recent articles are the co-author Maria Coleta and the Capuchin Friar, Slavery, Salvation, and the Adjudication of Status, with Carlos Venegas, that appeared in the William and Mary Quarterly in October of 2019. How does the law put a historical analogy to work, defining the imposition of a condition analogous to that of a slave in modern Brazil, with L.A. de Andrade Barbosa and C.H. Haddad. This appeared in the Duke Journal of Constitutional Law and Public Policy in 2017. And Social Facts, Legal Fictions, and the Attribution of a Slave Status, The Puzzle of Prescription in the Law History Review, 2017. And Public Rights, Social Equality, and the Conceptual Roots of the Plessy Challenge, which appeared in the Michigan Law Review in 2008. Professor Scott received an A.B. from Radcliffe College and Harvard University, an M.Phil in Economic History from LSE, and a PhD in History from Princeton University. She is the recipient of a MacArthur Prize Fellowship and a Guggenheim Fellowship, and is a member of the American Academy of Arts and Sciences. She is a past president of the American Society for Legal History. She was president between 2015 and 17. Our final panelist is someone I met recently, relatively recently, a couple of years ago, and it's David Lefebvre, who is an associate professor of Latin American history and digital humanities at the University of Texas in Arlington. He's the author of Prize Fighting and Civilization, A Cultural History of Boxing, Race, and Masculinity in Mexico and Cuba, 1840-1940, published with UN Press in 2020, and co-author of The Third Century, U.S. Latin American Relations since 1889. He's also a director and co-director of digitization projects focused on African diaspora in Cuba and Mexico, and has worked on similar projects in Colombia and Brazil. His photography in Latin America and the Americas and the American South has been featured in numerous publications and solo gallery exhibitions. So these are our presenters. I'm going to give now the opportunity to Alejandro La Fuente to start us with this panel. So Ale, anything you want.
Thank you. Thank you so much, Manuel, and thank you for your kind introduction. These introductions get longer as we age. They take more time. I'm very grateful for the opportunity to be here, to you, to David Blight, and to the staff of the Gilder Lehrman Center for hosting us and for organizing this excellent conference. Yesterday we had a great day, and I thought it was we had great sessions, and I look forward to our sessions today. Ariela asked me to present today since we have so little time, and I want to use that time to to offer a brief summary of some of the main arguments and findings of our recent book, Becoming Free, Becoming Black, that you referenced before, that Manuel referenced before. It is a book that tries to offer a new look and tries to offer new answers to an old question, and that old question is it's about why and how in plantation societies, plantation slave societies that developed roughly in a contemporaneous way by the mid to late 19th century, the social implications of Blackness were different in at least some important ways. A free man of color in Cuba in the 1850s could marry a white woman, could attend public school, could participate in a religious association that allowed him to have some participation in public life. In Louisiana and Virginia, meanwhile, free people of color saw their churches and their schools closed, faced criminal prosecution for getting married across the color line, and risked being kidnapped, imprisoned, and even re-enslaved for staying in the state in which they were born. In Louisiana and Virginia, the presumption that civic acts could only be performed by whites was so strong that they were used by people of color in order to prove that they were not Black. Citizenship was strictly associated with whiteness, incompatible with African origin. In Cuba, the population of color faced legal limitations of various kinds that we discuss in the book, but the process of racializing civic acts as something exclusively white did not advance to the same degree. And the question then is why? And that's the central question really behind the book. Now, most previous scholars looked for answers to these questions in patterns of enslavement and in the legal regimes of slavery, what Tannenbaum famously called slave systems. In our view, however, the key to these divergent trajectories of racial differentiation is not the law of slavery, which has attracted the attention of most scholars, but the law of freedom, which was used as a crucial space for the creation of racial legal regimes, for race making. Laws regulating demands for freedom and manumission determined whether it was possible to move from slave to free state. But this was only the first step. The laws regulating the lives and institutions of free people of color created the boundaries between whiteness and Blackness, reserved rights only for whites, and imposed the gradations of Blacks, regardless of their status, regardless of whether they were free or enslaved. In our story, therefore, in our book, what mattered in the development of racist legal regimes was not a contrast between Iberian and English slave systems, but the connections between whiteness and citizenship, Blackness and enslavement. We therefore center our attention on the formation of free communities of people of African descent in each of these societies, and on how legal regimes contributed to race making by associating whiteness and Blackness with specific rights, social statuses, and limitations or opportunities. And we begin the book with a massive similarity. In all these three jurisdictions, local legislators made a systematic effort to associate Blackness with enslavement, to link Blacks, Negros, Negroes, Noirs with social degradation. The slave societies of the Atlantic built race as a category of difference through the law, converting Africans of various backgrounds into Blacks, subjects without honor, without history, without genealogy, erasing and compressing in the process a multitude of cultures, languages, histories, and experiences into a single category of degradation, becoming Black. Many legal prohibitions applied to all Black men and women, free or enslaved, which helped to define degradation in racial terms, rather than in terms of enslavement. For the purposes of that legislation, the important thing was whether a person was Black or not whether that person was free or enslaved. And it's very interesting that the very first body of law that is concerning slaves that is approved in the Americas, a set of ordinances in Santo Domingo in 1522, is graphically called Ordenanzas de los Negros. It's not called Ordenanzas de los Esclavos. Despite these similar beginnings, however, by the second half of the 18th century, and we give specific attention to the age of revolution, which in our conceptualization goes somewhere between the 1760s and the 1820s, Cuba, or more specifically Havana, which is really the unit of analysis that we use in the book, had a much larger free population of African descent than New Orleans or Virginia. In Havana, it was about 15% in the 1770s. It was less than 1% in Virginia and about 3% in New Orleans. Needless to say, the existence of a sizable community of free people of color complicated enormously the association between Blackness and enslavement that local regimes had sought to inscribe since the early colonial period. So in this sense, then, it is somehow surprising and indeed contradictory that such a community would develop in Cuba. Because if you want to create a strict association between Blackness and enslavement, then the very existence of free Blacks complicates that association. So why did this happen? The short answer that we offer is that unlike Virginia and Louisiana, in Cuba, manumission, that is to say, the right of a slave owner to grant freedom to an enslaved person, was never legally curtailed, opening up opportunities for the enslaved people to obtain their freedom, to make claims, to push for their, to demand freedom, to purchase their freedom, and to move out of enslavement following different strategies. In both Virginia and Louisiana, by contrast, manumissions required since the early 18th century additional official approval in order to be effective. Therefore, those communities were considerably smaller by the time of the age of revolution. It is a divergence that began with legal traditions, as Tannenbaum emphasized years ago, in the sense that the right of manumission was firmly established, firmly rooted in the Iberian legal world of slavery. But the fundamental thing for us is that in the Iberian world, manumission was not linked to race, was not linked to the construction of a racial order. In the Iberian world, manumission was linked to the practice of ransoming Christian or Muslim captives and was conceived as a transaction with pious implications that apply to people of very different origins, including those from the Eastern Mediterranean who would later be described as white slaves. This is a key difference with Louisiana and Virginia, where the regulation of manumission became part of the construction of a racial order that identified freedom with whiteness and Blackness with enslavement. In any case, legal traditions are an important reference point, but the story, of course, did not end there. You cannot move from legal traditions to the 19th century, which is one of the problems of some of the comparative scholarship in the past. In fact, during the age of revolution, we find significant similarities. This is a moment in which legal barriers to manumissions were eliminated, both in Louisiana, then under Spanish rule, but also in Virginia. Virginia's free population increased significantly between the 1770s and the early 1800s. And for a time, it looked like Virginia and Louisiana would see the emergence of free communities of color similar to that of Havana, communities that would achieve what Kimberly Hanger has called such a critical mass that they could no longer be eliminated. But there was a crucial distinction behind this similarity. You know, the example of Haiti hovered over slave owners everywhere, but the political connotations of Black freedom were fairly different in Virginia than in Cuba or in Spanish Louisiana. In Cuba and Spanish Louisiana, manumission, the very existence of communities of free people of color, were linked to traditional and time-honored practices, enslaving, to notions of Blacks as royal subjects and vassals. Manumission was an institution of the ancien regime, not an institution of the revolutionary Atlantic. In contrast, in Virginia, new regulations of manumission and subsequent anxieties about the growing free population of color were linked from the outset, from the very beginning, to debates about general emancipation and about Black citizenship. Numerous popular petitions described free Blacks as an evil that would end up destroying the state, the new state, and therefore those petitions requested the abrogation of the manumission law of 1782. It's interesting because in those petitions, they speak of manumission as partial emancipation. They link manumission with the end of slavery. So it is not particularly surprising that as early as 1806, Virginia and Louisiana would follow up very soon, began to reintroduce barriers to manumissions. In Virginia, a legislator provided that any slave who obtained freedom would have to leave the state in 6 months. In Louisiana, a law of 1807 provided that any new manumission required, as during the French period, official approval. None of these regulations really prevented the actions and initiatives of enslaved people and their families, but they clearly indicated that freedom and citizenship were conditions reserved only for whites. Now, we identify a turning point in the legal regimes concerning free people of color and a new start in the kind sort of diverging trajectories concerning race in these societies in the 1830s. When several events made the free population of color appear increasingly as an intolerable threat to whites. This is a period characterized by the interrelated pressures of abolitionism, Black rebellion, Turner, for instance, and a growing population of free people of color. The 1830s marked the beginning of a true legal onslaught against free people of color. In addition to efforts to remove and send them to Africa, the famous colonization efforts, new provisions established restrictions on movement, restrictions on their right to remain in their places of origin, and restrictions on their property rights. In both Virginia and Louisiana, the idea was to remove free Blacks altogether, to make sure that every person of African descent would be enslaved, or at least to get as close to that ideal as possible. Both states passed quote unquote voluntary re-enslavement laws in the 1850s. And in both states, there are examples of free people of color who used such legislation in order to stay close to their loved ones. Both states also took steps in the 1850s to ban manumissions altogether. The free community, the free color community of New Orleans, which was the largest in the American South during the 19th century, collapsed socially and demographically in the 1850s. The association between freedom and whiteness in Virginia and Louisiana was so strong that demands for freedom in these territories took the form of legal claims on racial identity. In other words, in order to seek freedom, the plaintiffs had to prove that they were not Black, because Black freedom had become a legal impossibility, or as a contemporary source put it, an absurdity. Now, the free population of color suffered a legal assault also in Cuba, particularly after La Escalera, the repression of La Escalera in the 1840s. And the clearest expression of that assault was the temporary dismemberment of the militia of battalions of Pardos and Morenos, one of the traditional institutional platforms of the communities. Cuban slave owners looked at the US South with envy and noted what was happening in the US South. As the Havana Town Council noted in 1826, I'm going to quote, "In the United States, it is absolutely prohibited for any master to give freedom to his slaves, because they believe that freedmen awaken fatal ideas and desires among those who are not." End of the quote. The Captain General of Cuba candidly acknowledged in 1832, I quote, this is probably my favorite quote from the book, "Having made the mistake of not placing obstacles to freedom, to make it difficult and slow, and making matters worse by the indifference with which the propagation of free Blacks has been met, it is now imprudent to try to correct all omissions and defects." End of the quote. Colonial authorities in Cuba, therefore, saw the community of free people of color as simply too large a community to be eliminated. So I close by saying that by the time we finish the book, late 50s, early 60s, an enslaved person in Cuba would encounter free people of African descent on a regular basis. Such possibility was rare, even impossible in many areas of Virginia and Louisiana, which in turn helped to consolidate the link between Blackness and enslavement, between whiteness and citizenship. the very existence of free communities of color was an obstacle to the creation of a racial order as it was envisioned by legislators in all these jurisdictions from the beginning. As Supreme Court Justice Roger Taney said in the Dred Scott's infamous decision, in the United States, the perpetual and impenetrable barrier was not between the enslaved and free, it was between blacks and whites. Now, this barrier also existed in Cuba, of course. It was just a little bit more permeable, less impenetrable than what Roger Taney said about the US. And with that, I'm gonna finish because I think I've used our time, and I look forward to your comments and questions. And Ariela will, of course, join us for that.
Thank you very much, Ale. Okay, so now we have Professor Rebecca Scott.
Yeah. Hi, can you hear me okay? I'm going to stand up after a day yesterday spent sitting down. So many thanks to David and Anne and Adriana and Manuel and Melissa and Tom and Michelle and Danielle, all of whom not only put this together, but then adapted when circumstances changed. So what I'd like to talk about today, I think, links up very, very closely with what Ariela and Alejandro have been doing with the kinds of questions they've looked at. I've been increasingly preoccupied with, in some sense, the flip side of what they're talking about, the phenomenon that I tend to think of as peremptory enslavement. That is to say, the exact opposite of moving from a legal status of slave to free. This is instead a process by which people were moved from a legal status as free to slave. It represents the kind of moment in which some form or other of custody came to be seen as sufficient to place a person into the status slave. Now, we know, of course, that for African captives transported across the Atlantic, this generally happened upon arrival, when the creation of a sales receipt transformed someone into a newly renamed individual, ostensibly owned as property. But this process of peremptory enslavement could also occur under quite different auspices and could befall previously free persons in a variety of circumstances. I think it's important to emphasize that peremptory enslavement was a legal process only in the very loosest sense. An authoritative looking piece of paper might or might not be generated, but the perpetrator could usually count on nearly total impunity, and it was characteristically close to impossible for the victim to identify a legal hook on which to challenge that which had just happened, the enslavement that had just happened. And so in analytic terms, I think this raises an important legal historical question. If the core of 19th century slavery, both in Cuba and elsewhere, was the construct of property in persons, then where should we look for what property scholars call the root of title? That is, the original ground for the claim of property in that particular person. Or to put it somewhat differently, how was the fiction of ownership, the legal fiction of ownership, brought into being in a specific individual? The question here is not really philosophical, and it's somewhat different from the classic abolitionist proposition that all slavery was founded on man stealing, a proposition that is correct. This is a distinct question, however. To put it bluntly, how did enslavers get away with it? How did this come to pass? So I'll look at one set of events and their implication in two different places in Cuba to try to hint at, my notes say some preliminary answers to this question. It might be a little more accurate to say some paths toward finding some preliminary answers to the question. So the event that highlights the phenomenon for me is the arrival on Cuban shores in the summer of 1803 of close to 15,000 Saint-Domingue refugees. And what struck me listening to Alejandro just now and thinking about Alejandro and Ariela's argument is we're right smack in the middle of the period there that you're describing as the period of pivot, that moment of revolutionary transformation identified, among other things, with the Haitian Revolution. So among these many, many refugees arriving on Cuban shores were thousands of people of African descent, not one of whom was legally a slave in the jurisdiction from which they departed a few days earlier. I think this is an important point to emphasize because you will find hundreds of references in historical scholarship to the arrival of Saint-Domingue refugees and their slaves. It is crucial to recognize that in the jurisdiction from which they came, the very possibility of holding title to a person as property had been extinguished by law in Saint-Domingue across the successive decrees and statutes of abolition enacted during the Haitian Revolution, and that extinction had been secured by the political power of Toussaint Louverture and those who accompanied him. So as refugees moved in 1803 under the pressure of warfare, that is to say, under the pressure of the French expeditionary force attempting to reimpose slavery on the jurisdiction, as they moved from the anti-slavery jurisdiction of Saint-Domingue to the burgeoning slaveholding society of Cuba, they generally disembarked in Santiago or in Baracoa. The question immediately arose, although it was sometimes unspoken, would some of them be transformed now into persons with a price? Or to put it differently, by what mechanism could free people be claimed as slaves? So let me turn first to the question of sources, of how we would find sources for this. My sense from yesterday's discussion is that in this particular gathering, we are among friends, that is to say, fellow adepts of archives. I noticed in the chat function last time that many of the questions that came in were, where could I find this or that? So let me be explicit in this case. Let me say a little bit about the sources we have in addition to the classic sacramental records, legal case files, and notarial records that we've come to expect to find in Cuban archives. So I'll mention 5 different kinds of sources. There are some passenger lists from the arriving ships, along with declarations made by their captains when they reached shore. These have survived in the Cuban National Archives in large quantities, and they're accompanied by narratives by the captains, generally uttered to a notary upon the moment of arrival, in which they explain how they came to be transporting so many persons in search of asylum. So this is the first place where the question of descriptors, terminology, and implied status can be discerned. Second kind of source, that same archive, Cuban National Archive, holds a list from July of 1803 of refugees who found lodgings with longtime residents of Santiago. And this inventory of tenants is particularly interesting for the multiplicity of terms in French or in Spanish that are used by heads of household to describe subordinated individuals among the refugees. Again, this echoes precisely with Ariela and Alejandro's argument about the terminology. So what terms do we find? We find the word domestique, implying domestic servants / slaves, but with the noun left undescribed. It's a kind of adjective turned into a noun all by itself, domestique. We find criados, perfectly ambiguous term describing either servants or an implication of slaves. And we find some references to esclavos, as well as other terms used to signify color, which, as Alejandro pointed out right at the beginning of his talk, is often, under certain circumstances, treated as analogous to a status term. I think what's clear from the rental list is that terminology was in flux in these first weeks after people had arrived. Some people studiously avoided trying to make the claim that some members of their household were slaves. Third set of documents. 6 years later, that is to say 1808, after the refugees had been in asylum in Cuba for 6 years, local officials, local Cuban officials, were ordered to compile lists of foreign nationals. This was in preparation for what would become the 1809 expulsion of those who were seen as French on the occasion of the initiation of the Peninsular Wars in the Iberian Peninsula, as France and Spain came into conflict, or Napoleonic forces and Spanish residents came into conflict. Those who had a nationality as French were increasingly seen as potentially residents or not, absent residents of an enemy power. So these lists were drawn up. And the one that's been most useful for me is the one for Baracoa, carefully organized by date of arrival of the individual refugee household, organized by household, through this, we can identify individuals by name, and we can begin to see something of the complexity of the refugee community, the San Domingue refugee community, as it existed in Cuba. Fourth set of sources, I'm only going to go to 5. One could go indefinitely, but this is the fourth. Complementing the passenger lists for the 1803 arrivals are some ships manifests and passenger lists for the outgoing voyages during the 1809 expulsion. Again, some of those lists are nominal. They make it, that is to say, name by name, they make it possible to do some reconstruction. They can also then be linked up with published accounts of individual ships, names of individual ships as they arrived in US ports. As all of you know, these are now fairly quickly word searchable through America's historical newspapers. You can see the boats departing, you can see the boats arriving, and in the case of Louisiana, in the case of New Orleans, you can then pick up the thread of record keeping as people arrived in Louisiana. Finally, the last source that I'll mention, all of these previous sources, all these previous 4 kinds of records, help us understand the presumptions and the transformations of status that either occurred or people attempted to bring about upon arrival and during their years in Cuba. Then, as the crisis of expulsion arrived, there was a kind of generalized apprehension on the part of elite San Domingue refugees about what would happen with their next shift of jurisdiction. And my colleague Andrew Walker and I have found a document deep in the holdings of the US National Archives in a fondo called Miscellaneous Correspondence Received by the US State Department. I think the dates are like 17 something to 19 something, massive holding with a certain amount of catalog to it. And deep in that holding is an incoming petition to the President of the United States signed by 100 San Domingue refugees, elite refugees, in which they petition the United States government to seek to introduce those whom they describe as their domestique, again, it's in French, they use that ultimately ambiguous term. They seek to be able to introduce them into the United States despite the 1807 ban in federal law on the introduction from overseas of any person to be held or sold as a slave. So in this document, you see the use of the term domestique. The claim to own persons as property is submerged in the petition in order to evade the 1807 ban. So it gives us, I think, a glimpse of an attempted peremptory enslavement in kind of slow motion. The elite refugees hope to be able to slide into the jurisdiction of the United States while holding custody over those whom they are describing as domestique, and then be able to transform those persons silently, without any further legal process, into slaves once they're settled in the new country. So this petition, Andrew Walker and several other colleagues and I are working on, we've done a transcription and translation of the petition in order to analyze it. So these sources, these five different kinds of sources are at the heart of my ongoing and very hard to finish book manuscript titled No Safe Harbor, 3 Women Between Freedom and Slavery. And there's no way to sketch out in the moments that remain. Manuel, I'm not sure how many such moments there are. I didn't look at the clock, but I think I got 4. Okay, no way to sketch out in the moments that remain all the mechanisms that were used to carry out peremptory enslavements of people who had lived as free. But I'll signal 2 patterns that I've discerned. And I think they're going to link up quite well with things that Ariela and Alejandro have argued. So one step in the process of enslavement, this is to say enslavement happening in real time on American shores, whether San Domingue, Cuba, or the United States. Well, it involved imposing specific terms on accompanying passenger lists or other lists of names in order to evoke a presumption through the term negro, or one of its analogies, one of its synonyms, in order to impose a presumption of status. That is, in order to try to make that implication of negro, of the equality of the term negro and the term esclavo, despite, and it's interesting because this is despite the fact that the vernacular certainly also contains the alternative phrase, negros libres. I think it's important, particularly for scholars of Cuba, to emphasize, scholars of Cuba and of San Domingue, to emphasize that it was not simply the term mulatto that could be associated with libre. The term negros libres was perfectly available, but that coexisted with a deep-seated presumption around the term negro that it would signify slave status. And so that's one mechanism that's used. It's not foolproof, but it creates an initial presumption. A second mechanism, and this one is one that's it's taken me a long time to try and figure out how to enunciate it, is the process by which some form of apparent custody or imposition of dependence could be performed in such a way that it became a proxy for possession. Because possession, and here Ariela can tell us more about this because she's a scholar of property, but possession can be evidence of title in lots of situations. In the case of a relationship between human beings, however, claiming possession over a person in some sense presupposes that this is the kind of person who can be possessed. So it replaces an absent proof of title with a kind of social marker of control. And the question then is displaced. We still have to answer it. What made power over certain persons readable as possession, thus evidence of ownership, while power exercised over other persons could be seen simply as a component of patriarchy or of class dominance? Again, color is not the simple determinant of this. I think there's a whole set of other kinds of acts and performances that are necessary in order for custody to be read as possession. So it won't surprise you that the best method that I've found to try and understand and uncover the dynamics of enslavement has been to build up microhistories that reveal the mechanisms that were used across the life cycle. So I look at a case of peremptory enslavement of a child, specific mechanisms that go with that. I look at an instance of attempted peremptory enslavement of a woman who was a mother, and that's the one where it's one of the ones where I find the most conflict in the system, the capacity of that mother in some cases, in some settings, to push back. And I look at a case of peremptory enslavement of a grandmother. The three women are not in the same lineage, but they represent different points in the life cycle. So I'll just say a word or two about each one. What I would say is that the enslavement of some among the Saint-Domingue refugees did not rest on details of doctrine or formal adjudication. It instead involved the stealthy creation of a story or a file that could support a legal fiction, one that might or might not ever make its way into the judicial record. So in the case of a child, the child named Sanit, born free in the city of Cap Français, born free by definition in the city of Cap Français, some 6 or 7 years after the abolition of slavery in Saint-Domingue. And so I began tracing her history when I found her recorded as an enslaved person in Louisiana. More than a decade later, I traced back to Cap Français and then to Santiago. So she was about 5 years old when she was evacuated from Cap Français by a woman named Marthe Boyer. So we know only the first name of Sanit. We know 2 names for Marthe Boyer. Boyer herself would later be designated by the term femme de couleur libre, free woman of color. And Sanit was often described in French with the feminine diminutive form of the word nègre. She was often described as négrite. So the nominal component of enslavement is visible. Under the law of the jurisdiction from which they'd come, both Sanit and Marthe Boyer were both fully legally free. But as they disembarked in Santiago, their respective positions were quite different. Transporting the young Sanit with her, Marthe Boyer was establishing custody. She was in effect presenting herself as the head of a small household consisting of herself and this child who, according to her neighbors, served her. So the position of dominance, indeed, may have made it easier for Boyer to assert her own identification in Cuba as what would eventually be called mulata libre. After about 3 years in Santiago, Boyer brought together a group of neighbors and had them attest to their knowledge that Sanit was the slave of Marthe Boyer, thus completing the process on paper of creating that story. The second micro-history is one that some of you are already familiar with, which is the history of Adélaïde Métayer, born into slavery in Cap Français, freed, and then lived in asylum in Jamaica and in Baracoa. And one thing to note here is that Adélaïde Métayer, who had become free and had a small piece of paper, not a legal piece of paper, attesting to that freedom in Saint-Domingue, succeeded in establishing her own identity as a free woman of color in Baracoa. But in Baracoa, she got into an argument with a neighbor who used the word slave to describe her as part of their argument. And it's interesting here that we find the first instance of Adélaïde coming before Cuban officials to try and force her neighbor to take back this charge. Adélaïde then also takes her piece of paper and gets it recertified by Cuban officials. Now, I don't mean to suggest that Cuban officials had any particular interest in helping Adélaïde Métayer document her freedom, but in the circumstances of interacting with the refugee community, they were willing to treat those matters of status as largely internal to the community. And by the time that list of foreign residents of Baracoa was drawn up, Adélaïde Métayer was a mistress of her own person, head of her own household, which now held 3 children. She came into great risk of enslavement when she reached New Orleans rather than in Cuba. So in conclusion, as we as historians and writers shift our own use of terminology from the word slave to the word enslaved, I think we should remain on the lookout for the processes implied by that term enslaved. Because at the end of the day, no matter how entangled slavery was with law, the initial peremptory acts of enslavement rested on virtually no law at all. Just a set of conventions of commerce in the case of Africans brought to American shores, and presumptions to power in the case of the Saint-Domingue refugees. Thank you.
Thank you very much, Rebecca. And finally, we have David. David, are you there? I cannot see you now.
Yes, can you hear me?
Yeah, now you're on now.
Okay, great. Well, good morning to everyone. Muy buenos días y buenas tardes a todos. I'd like to thank Manuel and Ariela for inviting me to participate in this conference, and I'll try and keep my cat out as much as possible. And also Michelle and David Blight and Daniel for organizing and putting all of this on, and my fellow panelists, of course. It's an honor to be included in this, especially given the relatively recent nature of my work in this field. My first book was a history of boxing, so I'm fairly far afield at this point after about 3 years of work. I'd hoped to be in New Haven working at the center on a fellowship, but due to the pandemic, these plans have been postponed. The pandemic also kept me out of Cuba, where I plan to continue research on this project over my last semester's sabbatical. I've chased the phantom case file that covers much of these events, arriving in the archive of the Supreme Court in Madrid one morning to be told that the roughly 5,000 pages of testimony from West African, Cuban, Spaniards, Portuguese, Maltese, Mexican, Chinese men and women, testimony that had crossed the Atlantic from Havana to Madrid in 1865, had burned in a court fire in 1907. We're all used to these sorts of setbacks in our work, I think. Back in Havana, as one of our panels mentioned yesterday, I dove into the miscellaneous expedientes, the miscellaneous files, and was thrilled to find scattered pieces of the court case that I'll detail today. Because the dozens of legajos are often mislabeled and dispersed with no discernible order, I'll need much more time to locate and digest all of it. Though, as with much of our work, many of the documents in the Archivo Nacional are disintegrating, and it often takes a lot of my best negotiating skills and cajoling to convince the archivist to let me see them. But there are other ways, especially provincial and ecclesiastical archives, that we can trace many of the victims of the illegal slave trade that I'd be happy to discuss further in Q&A. And I'm going to attempt to share a screen real quick to take us back to 1863 and 1864 and give us some spatial and visual orientation. 1 second here. Okay, hopefully now you all are seeing PowerPoint. Are we good on the PowerPoint? Okay, so just a couple of images fairly quickly. So this is a period map of where our journey, our voyage of enslavement begins. The Bight of Benin, specifically the port of Ouida. The ship that I'm talking about today, according to Robin Law, was the last massive slave ship that ever departed the port of Ouida. This is the rough voyage the ship, the Cicerón, took many times, and it would expand its voyages to China, to Mexico, and to various places. This is the voyage of what we discussed yesterday as the Second Middle Passage. After arrival in the Bay of Pigs, the enslaved Africans were forced march across the Zapata swamp into Colón and Aguica, after transferred by new rail to Havana, and then dispersed all over the island as emancipados. I've been able to trace 1,100 of them at this point. This is an image that Rebecca will probably recognize. So these are some of the pictures of emancipados, and we'll explain what that is in just a moment, working on the Canal de Bejuco, which is the canal that still brings a great degree of the supply of water to Havana. There's a decent chance that these individuals came from the particular ship, given the timing and the percentage of members of that ship who were working on the canal project at that time. Another image of some of the forced labor on that canal on public works. If we have one, this is probably the villain, who we've talked about quite a lot. This is Julian Zulueta, one of the largest slave owners in history, and probably the wealthiest person in the Spanish Empire in the 1860s that I'll talk about. This is Domingo Dulce, who was the Captain General of Cuba for most of the Civil War. This image to locate us in the harbor of Havana. We've got the juxtaposition of a vessel using sails and a side wheel steamer. So this advent of steam technology, as we'll discuss in a moment, was very impactful in terms of the scale of the slave trade in the latter period. Image most of us are familiar with. This is the Ingenio of Álava, now known as Mexico, that most of the enslaved individuals were destined for. It was one of the largest producers of sugar owned by Julian Zulueta. Some of the documents that have been useful and that we've been digitizing, I'll discuss in a minute. This one is from the province of Las Villas, and it's one of the sets of documents that we can use to trace a number of these individuals. It's painstaking. Most of these are not digitized. You have to travel to local archives where access is often difficult and complicated. This is an entire falsified parish register from Colón, in which the local parish priest faked the deaths of about 141 of the Africans from the Cicerón in order to sell them into slavery and cover their tracks. This is one of the documents that I'm using to trace them. This is a register of emancipados from 1865, the details to whom these individuals were consigned and the places on the island that they went. So this is one of the clues that we use to then go to parish archives in particular and trace individuals through those means. This is one of the outcomes of the wealth of Zulueta. This is an art museum in Vitoria in Spain, which recently, a couple of months ago, unveiled a heretofore unknown portrait of Zulueta, and he's still celebrated as sort of a local hero and a patron of the arts and various other educational institutions. Getting toward the end of the images here, this is the barracón that was constructed by Zulueta in Central Mexico. It housed hundreds of families at the time, and now there are around 30 or 40 families that still live there. And it's also the site of a local museum from Senora Zulueta, fittingly enough. One of the churches from the Ingenio that now known as Benito Juárez, that Zulueta built to more effectively evangelize his enslaved Africans, Chinese people, and also Yucatecans, Mayans. A shrine that I'll speak about that's in existence, this one is to Ogun, and this is in Central Mexico, one of 4 or 5 shrines that are from Santeria or Bacuá or various other Afro-Cuban religious practices. An image of the Ingenio, which still is the walls that were built in the 1840s and is still in operation. Most of the sugar is now sent to China, according to the workers there. A festival in the Ingenio in Central Mexico. One of the images of enslaved Africans likely taken near the plantation in 1862. This is in the Getty collection. And then finally, I'd like to end on this image for the visual portion. This is Senora Zulueta, who is the woman who runs the local museum and who was my informant in a sense for some of the oral history that I'll go through briefly. Okay. So I'd like to start by introducing 4 separate but related incidents of exile, rendition, and kidnapping in the year 1860. Occurred in Havana. The second and the largest involved 1,300 Africans purchased in Huida and loaded onto Colón, and the last one in New York. Shortly after his arrival and of command of Cuba in late 1862, Captain General Domingo Dulce, his primary goal was to end the illegal slave trade, exiled two notorious slave traders and plantation owners, Francisco Durañona and Antonio Tued. An enraged Spanish press called his acts wanton acts of tyranny, and the attorneys for those exiled produced a lengthy brief detailing laws on exile in the empire dating back to the 16th century. In addition to Durañona and Tuero, Dulce mandated the exile of over 20 Portuguese subjects for the same series of crimes or suspicions. All of these were done extrajudicially, which made even Spanish liberals cringe. Shortly thereafter, the Captain General also removed from his post and exiled the civil governor of Havana, Pedro Navasquez, because he had fraudulently issued passes to transport bozales under the guise of criollos to one of the plantations of Julián de Zulueta. Dulce, recently in his post, likely did not fully understand precisely who in Cuba was meant to be untouchable. These cases of exile were raised to the Queen in Madrid, and though she regally recognized his actions as reasonable, she allowed nearly all of the exiled to return to Cuba and take up where they left off. The fourth case, which will become even more notorious around the Atlantic world, was the order by Abraham Lincoln and Seward for the kidnapping and extraordinary rendition of the Spanish Colonel Jose Agustin Argüelles from New York. Accused of plagio de negros, which is selling legally free people into slavery, but one translation is a plagiarism of those people, falsifying documents, for example. At his post in Colón, a sugar boomtown in Matanzas only recently founded in the 1830s, the events that crystallized in the Argüelles case exposed the series of actors, corruption, and international legal regimes that would culminate in the end of the slave trade to Cuba. A few months after the Emancipation Proclamation, and at the end of Domingo Dulce's first year in Cuba, 1,300 Africans from Huida in modern-day Benin were forced aboard the steamship Cicerón and carried on a voyage from West Africa to the remote and sparsely populated Bay of Pigs in Cuba. The ship had escaped pursuit by a British warship after cutting its anchor chain and speeding into the Atlantic. The commercial value of its human cargo, mainly Fon and Yoruba speakers, women, children, and men with an average age of 15, held for the slave traffickers the modern equivalent value of $30 million. Such enormous sums enabled the ship's owners to outfit with the latest maritime technology and to stock immense coal reserves that enabled the ship to outpace abolitionist pursuers. The steam age enabled the slave trade. Off the southern coast of Cuba, the Cicerón delivered its cargo. Over 8 hours in darkness, the crew unloaded nearly 1,300 naked human beings, among the last and one of the largest human cargoes to be illegally forced into Cuba. The chronology of deciding which one is last is notoriously difficult. The Africans from the Cicerón were carried onto smaller boats that fellow conspirators rowed from the beaches after a prearranged lantern signal. The captives, many sick with smallpox despite attempts to inoculate them in Huida, disembarked near a small creek and were force marched for several days inland through the malarial wastes of the Zapata swamp, a dangerous route undertaken to avoid the detection of the few local officials who had not been bribed. Together, these constituted a series of criminal acts under international law. After 1820, the slave trade was illegal, but nearly every institution in Cuba was complicit in the continued trade: the church, commercial houses, the press. The central actor among the many conspirators was Julián de Zulueta, arguably the wealthiest slave owner in the world by the 1860s and one of the largest single slave traffickers in history. His fortune, based on the enslavement of Africans, drew income from the United States, Great Britain, Spain, France, and as far afield as China, where he hedged his interest in African slavery by indenturing tens of thousands of Chinese men. Jose Agustin Argüelles, the military commander of the District of Colón, and Jose Valdez, the parish priest of the city of Colón, likely aided him in this instance. They falsified nearly 200 of the Africans' deaths and cremations and sold many into slavery around Colón, the crime of plagio de negros. Argüelles granted leave by Dulce for 20 days to travel to New York City. There he hoped to combine his reward money granted by the Spanish colonial government in return for his capture and his proceeds from the plagio to buy the newspaper La Crónica and reinvent himself as an abolitionist journalist. Ironically, after illegally selling enough enslaved Africans to fund his literary pretensions, he hoped to live up to his namesake and uncle, Agustin Argüelles, who 60 years before had argued for the abolition of the slave trade in the Constitutional Convention of Cadiz and was also instrumental in the Constitution of 1837, through which Cuba lost formal representation in the Cortes. But this Argüelles, from his Maillard's hotel room Manhattan in February of 1864, penned a stinging pamphlet titled Domingo Dulce and the Slave Traders, in which he accused the war hero and captain general, a man famed also as a morally driven abolitionist and defender of human rights, of being in the pocket of Zulueta and other enslavers. Though Argüelles had documentary proof of this, he claimed, the dozens of newspapers in Madrid refused to print, worried about libel laws and the displeasure of the Spanish crown. Though printed in New York, the details of official corruption and the purposeful complexity of Spanish laws on the slave trade, property rights, and state intervention made the document opaque for most US readers. Regardless, the pamphlet circulated widely. Within a month, it reached Europe, the United States, and various parts of Latin America. Until the end of the 19th century, memory of this series of events echoed in the US press as their most egregious example of a modernized Black legend. Despite the absence of an extradition treaty between Spain and the United States, Abraham Lincoln acted on secret communication between Dulce and Secretary of State Seward. Likely deceived by the general, Lincoln ordered the abduction of Argüelles by federal marshals and his clandestine rendition to Cuba, thus setting an important legal precedent on extraordinary rendition that has been cited up until the present and the George Bush II administration to justify extraordinary rendition to CIA black sites. The marshals, headed by the raffish abolitionist, then faced kidnapping charges in New York, beginning a legal odyssey that would reach the US Congress, the Supreme Court of Spain, and the Supreme Military Court of Cuba and the US Congress. Through the press, these events invigorated the transnational public sphere with a renewed debate over the slave trade, modernity, and international law. Even US abolitionists, such as Wendell Phillips, were outraged at Lincoln's executive overreach, despite the fact that this rendition, in theory, led to the freeing of a portion of the illegally enslaved. This international embarrassment for Spain, opined upon by the press in dozens of countries, further impugned Spanish civilization and the increasingly moribund colonial. It forced the hand of the Spanish government and became a primary justification for increased pressure from the British and US governments for effective reform of Cuban penal law, demanding the unfettered search of private plantations and fincas for suspected bozales, and finally declaring the death penalty for slavers. Soon after these events, the Spanish press, as a result of the Argüelles affairs revelations of the depths of official corruption and the enormous fortunes generated by the contraband trade, called on the Spanish parliament to act, which it finally did in 1866 with watered down laws that we can discuss more later. I want to skip forward a little bit. There's a lot of complicating factors that hopefully will come out in the book. In the United States, the Argüelles affair complicated Lincoln's candidacy for a second term. It was editorialized in pamphlets, speeches, and newspapers around the Atlantic world. The novel legal doctrines of extradition competed with the quote unquote sacred tradition of asylum, imperial and national sovereignty, and the very lawfulness of slavery itself, starkly evoked in nationalist posturing in the United States and from parliaments of the Queens of England and the Queens of England and Spain. This manuscript also relies on newly located and digitized primary sources, documents from Cuba brought to light by the parallel project Siete Vidas de Cuba, which is in the process of digitizing over 1 million pages of endangered documents from archives in Cuba and publishing them through Jane Landers and Vanderbilt University's Slave Society's Digital Archive. I'd like to offer two final anecdotes that serve as reminders, and we can never be reminded too much of the inhumanity inherent in these events. 1 month before the Africans of the Cicerone arrived in Cuba on a plantation owned by a close associate of Zulueta, a young captive African man was caught visiting his girlfriend, who served as a wet nurse in the home of the plantation owner at night. The next day, the man was placed in a small cage, too small to turn around in or stand in. Over the course of several hours, the overseer beat the man slowly and methodically with the paddles of a nopal cactus. He bled to death, serving as an example in front of the other African, Afro-Cuban, Chinese, and Mexican captives. His girlfriend, Mercedes, committed suicide by drowning herself in the well next to the Ingenio, the sugar factory. To conclude, in 1878, upon the death of Zulueta and his lavish funeral in Havana, ships from all nations in the harbor, including the United States, sounded their guns in salute of the largest slave trafficker in Cuba. His lavish funeral was attended by the cream of Havana society and nearly the entire diplomatic corps. Today, a street in Old Havana where tourists now gaze in wonder at the monumental buildings constructed by the slavocracy still bears his name. In Spain, many institutions, including art museums, continue to draw on his fortunes generated by enslaved labor. Over the next few years, I hope to continue the painstaking work of tracing the Africans from the Cicerone in Cuba and beyond. It's essential that we provide their counter narrative. And the last thing I'll say was a narrative told to me by Senora Zulueta in explaining Julian Zulueta's death. She is one of the women who presides over the shrine of Ogun, who is the god of iron and warfare. And when Julian Zulueta died in 1878, she says that Ogun lost his horse through the horseshoe, the iron horseshoe that was wearing, and caused the horse to throw Zulueta off and to kick him in the head, seeking revenge for the enslavement of her ancestors. And I'll stop with that, and I look forward to any questions. Thank you.
Thank you, David. I am the one in charge of uploading. We will be taking questions now. Let me be clear, we are not taking questions for the cat, because I've seen already a movement in the Q&A. I'm being serious here. Okay, so I'm going to try to read you the questions that we have here. The first one is by Adrienne Van Dyke. She's asking, and I think this is a question for Ale and the first paper, yeah. Do you think the harshness of Calvinism versus the relative gentleness of Catholicism played any part, but it's not clear any part on what? That's yeah, sorry. So the second question is by Stuart Schwartz. Stuart says, and this is for Ariela and Alejandro as well. So Tannenbaum was partly right. There was a legal difference between the US and LA, Latin America, I guess, but it was not about slavery, but about the status of ex-slaves. So he asked, Ale, you don't say much about the role of racial mixture, for example, mulattoes on the legal status of free people of color, or about the considerable distinction in social status and opportunity depending on the degrees of Blackness. Can you comment?
I'll take a shot at the two questions. I think Adrienne Van Dyke clarified below that. She said that is to say.
Yeah, I just saw it.
So I'll start with that question, and thank you, and thanks to Ale for doing such a great job summarizing our whole book in 13 or 14 minutes. I'm glad for the question about religious, and cultural differences. Both of these questions actually relate to, ideology, theories about race, as well as religious differences. And I think that's actually one of the key divergences between our conclusions and those of Tannenbaum or some of the other kind of mid-century comparativists, because we actually didn't see Tannenbaum and some other earlier comparativists really made distinctions based on ideas not only about the role of Catholicism, but also portrayed a legal system based on Roman law that recognized the humanity of the slave, defining them as person, not chattel, and really painted a very stark distinction between the two systems based on that kind of idea that the Spanish system was, or any systems actually deriving from civil law and with the influence of the church were more humane. And I think, and we, by focusing on free people of color, in part, it was because of a recognition that there really was not that distinction, but the harshness, that there was nothing less harsh about Cuban slavery because of the influence of the Catholic Church. And we don't find a role played by the church in manumission that significantly influences those trajectories. And indeed, we argue that the slave systems and the legal systems of enslavement are, equally harsh and degrading. And so all you need to do when thinking about manumission and the influence of either the church or Roman law genealogy is to look at Louisiana, where the French arrive in Louisiana. They have a code noir that has been developed and has been at work in the French Caribbean already for decades. And based on their colonizing experience, they put into place in the 1724 version of the Code Noir a very strict limit on manumission. So, so just comparing the French to the Spanish, you already see that the French, based on that experience, have decided that free people of color are a menace, and that they want a very strict limitation. As far as the question of degrees of Blackness, I think that was also a really important aspect of traditional comparisons between the United States and Latin America, right? That traditional comparisons tended to emphasize the US as uniquely bipolar, black and white, and Cuba and other parts of the Americas as having a different racial regime because of a more fluidity or more categories, meaningful categories between black and white. And again, I think here's where that's a place where we really depart from that view. And what we argue is truly distinct in the racial regimes is not about the possibility of people on middle grounds between black and white. In fact, you know, I actually wrote a whole book about people on middle grounds between black and white in the United States. But the fact that that Blackness that becomes associated with exclusion from public life, and it's that link between citizenship and whiteness that that we really emphasize as the distinction, the place where the trajectories diverge. And it is, I think, especially notable that they diverge, begin to really